E-N-A.
E-N-A. Okay, I thought I
All right. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh, give their attention to the court, now sitting.
Please be seated. Good morning. I welcome all of you to the Kansas Supreme Court, both those that are in the courtroom, as well as those who might be on our watching our live stream. We have 3 cases on the docket this morning. We'll hear 2, take a recess, and then reconvene for the 3rd case. At this time, I would ask Mr. Shima to please call the first 2 of those cases at the 9 a.m. docket.
Thank you, Your Honor. May it please the court. The first case on the 9 a.m. docket for Monday, May 12th, 2025 is appeal number 127299, State of Kansas versus Kyle Romey, Sedgwick County, briefs both sides.
Good morning, and may it please the court, Grace Tran of the Appellate Defender Office on behalf of Kyle Romey, present and ready for argument. Your Honor, may I request 3 minutes for rebuttal?
3 minutes is granted.
Thank you.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Second case is appeal number 126718, in the interest of K.W.D. and E.L.D. minor children, Leavenworth County, briefs both sides.
Good morning. May it please the court, Jennifer Martin Smith appearing for the father in these 2 cases, and I would request 2 minutes of rebuttal, present and ready for argument.
2 minutes is granted. Thank you.
Thank you.
Good morning. May it please the court. Sarah Ikena, Assistant County Attorney, Leavenworth County for the state of Kansas, present, ready for argument.
Thank you.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. As you will notice, we are hearing cases this week without Justice Wilson. She will not be participating in today's decisions in either through argument or through in the decision making. So with that, I will ask the attorneys in 127299, State of Kansas versus Kyle Romey, to please come forward. Feel free whenever you're ready.
Good morning, and may it please the court, Grace Tran on behalf of Kyle Romey. In this case, there was insufficient evidence of premeditation, and also Kyle was denied his right to a fair trial because the district court refused to admit defense evidence, refused to give a requested defense instruction, and did not properly instruct the jury on premeditation. Kyle's conviction should be reversed. First is insufficient evidence of premeditation. In this case, the state did not put on evidence to show that Kyle had thought about beforehand and formed the intent to kill in this case. Ultimately, this case is a black box. No one really knows what happened inside that house on the day of the incident, and none of the state's evidence shows that there was any intent to kill formed before the act. And all of Kyle's behavior before and after the case did not support that there was premeditation here. Kyle, by all testimony, was helpful to his mother and had a good relationship with her, and also afterwards showed distress and got his sister to go and see their mother and lay down beside her and was attempting to comfort her. And so none of this evidence shows that there was intent or that he had formed premeditation beforehand.
Why isn't the evidence that there was an extended altercation, that evidence that he switched hands and evidence that he switched weapons are enough for a jury to infer? I'll give you that it's thin, but why isn't that enough under the law?
That's not enough because it relies on impermissible inference stacking. So with the example of the fact that she had a lot of injuries, right? So the ME testified the extent of her injuries. That leads to an inference that this took a very long time, which leads to an inference that there was enough time to form premeditation before the act or during the act of that. And ultimately, this court doesn't allow inference stacking to prove elements of crimes or to say that they're sufficient for a jury to have found them. And so because of all of this,
Well, can I follow up on Justice Biles' question? I think just honing in more specifically, there's evidence that his hand was swollen, a physical altercation, and then there's evidence that a instrument was used. So it seems to me that the change in tactic is contemplative. And I don't know that that is stacking inferences.
Your Honor, I think that even the evidence that his hand was swollen, that an altercation occurred, that even goes to the point that the defense had requested a voluntary manslaughter instruction, and with the language of a sudden quarrel or heat of passion, based on evidence of an altercation, evidence, of wounds that occurred that may have been defensive wounds, and that wasn't given. And so,
Yeah, it may lend credibility to that requested instruction, but are you suggesting then that that would be a reasonable inference, though, that switching of tactics in terms of the assault demonstrates contemplation?
Your Honor, no, I don't agree that that necessarily demonstrates contemplation. I think that ultimately, a lot of things can happen in the midst of a highly passionate um, fight or altercation that occurred. And just because one's hand might get tired during such an event, that doesn't necessarily mean that one has thought about it and formed the intent to kill before that has occurred. So no, we don't necessarily think that that shows intent. So moving to the voluntary manslaughter, like I mentioned, there was evidence here that pointed to an altercation occurring, pointed to a sudden quarrel or a very highly passionate, violent event. And that's the standard for giving a requested lesser, is that there must be some evidence to uphold to support the conviction. And so it was error in this case for the district court to not give the lesser that was requested because there was this some evidence. The house was in disarray, the furniture and items were broken. Like we've mentioned, Kyle had injuries to his body, and obviously as did Denise. All of this evidence supports that there could have been a fight that occurred and would support that there was a sudden quarrel or heat of passion. And this goes to several of the errors that occurred in this trial, which all get to that the jury was not allowed to fully evaluate Kyle's mindset and Kyle's state of mind at the time that this occurred, because the district court did not give this lesser that would have allowed them to consider this alternative circumstance. Also, that the district court did not let the defense evidence in of intoxication, which would have gone to Kyle's mindset. So ultimately, that's the overarching problem in this case, is that the jury didn't get to fully consider all of these circumstances when this case was such a black box of what happened. And so the jury didn't get the opportunity to consider all of the evidence, all of the potential charges or lessers. And so.
But they did get some lesser included offense instructions, I believe, right? Second degree. So if the jury didn't believe that this was a premeditated act, there was an alternative for them to convict on. When we are trying to ascertain whether any instructional error is prejudicial, we have to be, since you requested the instruction, it's not clear error, it's a lesser standard, but that the outcome would have changed. How do you respond then to that the jury didn't adopt any of those lesser included instructions that would have maybe evidenced that a theory other than premeditation?
We would suggest that since voluntary manslaughter includes these additional elements of sudden quarrel, heat of passion, that that would have been a more appropriate charge for or lesser for the jury to consider. And given the evidence in this case, that would be um, much more likely for the jury to have gone for, and therefore that's why um, the state can't show beyond a reasonable doubt that this was a harmless error. And so,
How do we weigh, in looking at that, the harm, whether the error was harmless or not, the fact that the defense filled in a narrative, a theme of what happened. And in the closing arguments went so far as to say that those injuries to your client were likely caused by whomever harmed mom, and went so far as to say, it wasn't his mom that caused the injuries. Does that really leave the jury much room to have come up with the theory you're now asking us to adopt?
Your Honor, ultimately, of course, defense can shape a narrative and put forth versions of events, and I think defense did that in multiple different ways throughout this trial, like the comments you've mentioned, also putting forth that potentially he was intoxicated to the point of not being able to form intent. And so ultimately, the defense's comments are just argument, and they may suggest to the jury ways that they should view the evidence, but ultimately the jury is the one, and they're instructed so that comments of attorneys are just that, comments, and that they should view the evidence. And so I think that if they were given the law from the judge that also could have formed the way that they viewed the evidence, in that they would have been able to um, use that law and look back and see if the elements of voluntary manslaughter had been met. And so also, like I mentioned, there was this exclusion of defense evidence, which again goes toward this overarching theme of the jury not being able to fully evaluate Kyle's mindset. And
Well, the defense evidence that you were requesting was a video of his interaction with law enforcement post um, at, during the time in which he was being interviewed. And wasn't there evidence that he had ingested methamphetamine either through the consumption of the water plus maybe other consumption of drugs after the attack?
Your Honor,
So what's it relevant for?
Your Honor, there was evidence that of possible drug use that Kyle had after the event. His sister.
Strong evidence, it seems like, from various witnesses.
Well, so the evidence from his sister was that he had drank bong water after the event. There wasn't even testimony of what that bong had been used to smoke or to ingest. So the evidence, which was the video, also a lab report that showed that he had methamphetamine and amphetamines in his system. There wasn't testimony that the bong had been even used to smoke methamphetamine or amphetamines in a way that there would be that residue in its byproduct. But ultimately, there was also evidence that he had used before the event. And so that's why this evidence was relevant, to show his state of mind at the time, because his sister had testified the morning of the death that before this ingestion that he had been acting erratically, as if he had been under the influence of methamphetamine, that he had been acting effed up. He told her that he had blacked out that morning. He did not remember what had occurred. And so ultimately, if the standard is for relevancy, any tendency to prove a material fact, because there was evidence that he had used drugs before, this evidence had some tendency to show. And of course, any issue of timing could have gone to the weight of the evidence for the jury, but ultimately the jury should have been able to review that evidence and make those determinations as the fact finder, instead of that evidence not being allowed to go to them at all. And so, and again, this evidence goes toward this critical issue in this case, which was that no one knew what was going through Kyle's mind at the time. And so, because again, the jury wasn't able to consider, does this evidence go toward an inability to form intent, to form premeditation before Kyle's right to a fair trial was violated in this case. And I see that I'm running low on time. I would stand for any further questions, and if not, we would just ask that Kyle's conviction be reversed, and I would submit the other issues on the briefs.
Can I ask you one question about your sentencing issue, your challenge? You're challenging his criminal history A status, and you're doing that through a couple different levels. The first level is the criminal threat convictions, correct? Based on our recent precedent, that seems consistent with that case law. But then he's still a criminal history A because of the personal misdemeanor convictions. So you're challenging the Louisiana conviction to knock out the third person misdemeanor offense. But it looks to me like the PSI shows yet another person misdemeanor, the 2006 Kansas assault conviction, which tells me that you could still aggregate 3 misdemeanor convictions and he would end up as the same criminal history.
Your Honor, I may be incorrect, but my understanding about the assault convictions is that they can only aggregate if they have occurred within a certain amount of time of the crime of conviction, maybe 5 years, possibly.
Well,
That's
the PSI aggregated a 1998 and a 2006 conviction, and I'm talking about another 2006 conviction. And I don't think you challenged the 98 or the 2006 person misdemeanor.
that's correct. My understanding, at least, is that with assault specifically, because the level of misdemeanor they can't aggregate unless they are recent enough to the crime. But again, I might be mistaken about that. Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Beginning with issue 1, obviously this court is aware of the standard of review for sufficiency of the evidence claims, but I think it always bears repeating that the evidence is viewed in the light most favorable to the state. And the question ultimately is, do you believe that not 1, not 2, not 3, but all 12 jurors in this case behaved irrationally in finding him guilty? Because that's what the defendant has to show, is that a rational fact finder could not have sat through this trial, viewed the evidence and testimony, and concluded that he was guilty of premeditated murder. Counsel has pointed to in her argument to the fact that nobody knows specifically what happened in that house. And I would only agree to a limited extent. Obviously, the defendant did not testify. He did not give a statement. We don't have any video of what happened. So to some extent, yes, it's a little bit unclear why this happened. Of course, we don't have to prove the why to prove premeditated murder. But we do have a very good idea. We have physical evidence in this case. We have the fact that this was a beating, a brutal beating throughout her entire body from head to toe. We had broken bones in her head. We had multiple broken ribs. We had a broken bone in her elbow. We had blunt force trauma to her legs. The coroner specifically testified that due to the number and locations of these wounds, that this was not something where it was simply one injury. This is not a case where we could say, well, maybe he threw one punch and it caused damage to her face and she fell and hit her head on the ground and that's what killed her. This is a lengthy beating throughout her body. And so to the extent that counsel is arguing that this is inference tracking, it is not. The coroner testified that these were multiple injuries. And as some of your honors have pointed out this morning, we have injuries inflicted both with his hands and with a weapon, which does, I would argue, as this court questioned counsel, I think that does show additional time to contemplate what he was doing here. I cited in the brief the 5 factors that generally are considered in premeditation. Again, we have a significant amount of blunt force trauma throughout the body. We have an indication that he used both his fists and a weapon. There's absolutely no evidence that the victim provoked him. We have his conduct after the killing, where it appears that he ran the washer to try and clean some of the laundry. He hid the knife in a different room. He prevented his sister from calling 911 and or driving from the police station to the police station. He didn't give any statements or testify, and there are no witnesses, so we don't know if he made any statements before or during the killing. But again, the fifth factor, whether there were injuries inflicted after she was rendered helpless, this was a prolonged beating. And I think that it is a reasonable interpretation of the evidence, the one that the jury could certainly have, that he did continue to beat her after she was rendered helpless here. So looking at all of these factors, our position is that the evidence overwhelmingly supports premeditation. The question is not whether counsel can identify other ways that the jury could have interpreted the evidence. The arguments that she's making are fine arguments to make to a jury. And if the jury had agreed with those, they would not have convicted him of premeditated murder. And I think it is significant not only for this issue, but for some of the other claims raised in this brief and today at argument. This jury was instructed on the lessers of intentional second, reckless second, and involuntary manslaughter, and they were given a voluntary intoxication instruction. And so while counsel has argued that the jury was not really given a full opportunity to consider the circumstances of the defendant's mindset, I think that the instructions and the way that this case was presented to the jury shows otherwise. They heard the evidence, they saw the autopsy photos, they listened to the coroner, they determined that this was premeditated, and I think the evidence overwhelmingly supports that. Turning to issue 2, the exclusion of the evidence that the defense sought to put on. First, I would point out that this was not the denial of a right to prevent a defense, certainly not a constitutional violation. They did get that instruction on, on voluntary intoxication. And there was extensive evidence put before the jury regarding the defendant's history of drug use or alcohol abuse. There was testimony about some of the items found in the house, including, I believe, a vodka bottle. The jury heard all sorts of testimony and evidence about this matter. The only thing that they didn't get was this evidence about the video that they wanted to show. And I would note, they wanted to show a very short segment of what was essentially a 3-hour period that he was in this interrogation room. And then they wanted to present this lab report. And the court's rationale, I think, was correct. We had the victim's sister testify, or the defendant's sister testifying that she personally saw him smoke this bong water after the killing. We also had her say that when he first arrived at her house, he did not appear to be intoxicated to any degree. And this was somebody who knew him, obviously, who was aware of his history of drug and alcohol abuse. And so I think she was certainly qualified to speak to whether he appeared intoxicated when he got there. And then this video was several hours after the fact. We know he had used drugs in the interim, and the lab report was taken 12 plus hours after the murder. So again, we know that that is going to show that there was some level of drugs in his system because his sister saw him use them after the fact. So I don't think that it would have any value whatsoever, regardless of what that test showing that he has drugs in his system. It's going to show that regardless of whether he did anything before or after the fact. And again, he chose not to testify or not to give a statement, which is certainly his right. But because he did not do those things, and because there's no other evidence that he had used or was under the influence at the time of the murder, the court properly found that those two pieces of evidence were not, in fact, probative. The fourth issue raised, I guess, was the voluntary manslaughter instruction based on the heat of passion or sudden quarrel. And I would just remind the court that it's an objective test. governing the question of whether there was legally sufficient provocation. And that has to be sufficient provocation to cause an ordinary person to lose control of their actions. And the case law from this court says that you do not speculate on hypotheticals. You have to have actual evidence to support it.
Does that objective test fall under the factual appropriateness prong of our standard of review or somewhere else?
I would argue that yes, because you're having to look at whether there would be actual evidence, that would be largely a factual determination, having to look at the facts of the case to determine whether they would be, whether it would be sufficient.
Because we know it's legally appropriate,
Yes, it is legally appropriate because it is a
but
lesser.
it's sort of a strange beast when we use the word objective standard. That makes us think sometimes it's a legal question.
Right.
It really is a factual question, isn't it?
That's what I would agree with
But
that.
your argument would be that this instruction was not factually appropriate because the evidence did not rise to the threshold of an objectively reasonable provocation.
Exactly.
Okay.
And I think essentially what the defense has pointed to is the fact that their house was in disarray and that there was broken furniture. But again, you would very much have to speculate on hypotheticals. You would have to assume first that that furniture was broken and that the house was in disarray because there was an argument between these two people. You would have to assume that that argument and that confrontation had happened at this point during or immediately before the killing. And then you would also have to assume that the victim was the one who provoked this incident and that that provocation rises to the level that it would cause an ordinary person in the defendant's position to lose control of his actions to the point where he would then brutally beat his mother to death. So there is very much a lot of speculating that would go into such an analysis.
Well, let me ask you something that strikes me as potentially different here than in Garcia and some of our other cases about, where the evidence was that scattered, and evidence of a protracted altercation. And here it's the forensic examination of the defendant after arrest, showing injuries to, if I get it correctly, the back of his head, swelling on the back of his neck, and abrasions across his back, especially in the lower middle back. Bearing in mind the inferences that you're asking us to draw on premeditation, why can't we infer, or why couldn't a jury infer from that evidence that he was attacked from behind?
I think that when you look at the evidence as a whole, you still can't escape the fact that the overwhelming evidence showed that he was the one who committed a very prolonged beating in this situation. And again, I think that because he chose not to give a statement, which is his right, but because he chose not to give a statement, we would have to speculate as far as how he actually got those injuries.
It's the timing, right? We don't know which happens first.
Exactly. We don't know which happened first. We don't even know for certain whether those injuries to his body occurred at the time of these incidents, at the time of this incident. So I still think that there's just too much speculating that would have to go on in a situation like that. And I would submit that in a normal situation where there is a beating like this, I think it's fair to assume that the victim will try to defend herself or fend off her attacker. And so it's certainly equally possible that even if some of those injuries to the defendant occurred during this incident, that it was as she was defending herself rather than because she started an incident that then provoked him.
Can I ask you one more thing while we're on this instruction? If a court were to find that it was error not to give this instruction and we were examining prejudice, and it really goes to Chief Justice's question earlier, where in closing, the defense formulates this theory about the evidence that these injuries were all caused to both the defendant and the victim by some other third party. But what do we do with that when we know that, well, they didn't get the instruction they requested, which may have opened this vehicle for a different interpretation of the evidence? Or are we just stuck with the record that we have?
Yeah, I certainly think it's relevant that they pursued that theory as part of their closing in this case. And so I think when you look, you can only look at the record that does exist and see what strategy they took here. And so I think that, yeah, it certainly does, in my mind, seem to be very detrimental to their argument of harm with respect to whether the error was harmless, when they themselves are putting this different theory before the jury. And so I think that makes it difficult to then say that the jury, that they can firmly convince this court that the jury would have returned a different verdict. I think that in all likelihood that this is a case where they were just trying to throw different things out there, because this is, again, I would acknowledge that we don't know why specifically this happened. This does seem to be a very bizarre situation where, according to the defendant's sister, that there didn't seem to be any history of discord between these two people. And so there is a natural tendency to speculate and wonder why. But I think when you look at, again, the physical evidence, and then you look at the defendant's behavior after the fact, counsel points to the fact that it appears that he was regretful in his actions after the fact. And while that may be true, it simply has no bearing on whether this was a premeditated act on his part. And we might likely never know why he did what he did. But I think when you look at the severity of the beating, the extent of the injuries, the fact that it was all over her body, that it did take time because there were so many different injuries, and that he used both his hands and a weapon, I think that the jury's verdict was certainly very reasonable in this case. And I don't think that the lack of the lone instruction, essentially, that he was denied in any way affected the outcome of the trial in this case. If there are further questions, I'd be happy to entertain them, but otherwise the state's position is that all of the defendant's claims are without merit and that his conviction should be affirmed.
And the sentencing issue, and I think, you know our State v. Smith holding that's come in on those criminal threat issues. And so now really we're focusing on the aggregation. And I'm wondering if you understood my questions to your opposing counsel about this third person misdemeanor.
I did, and I, like counsel, I'm not entirely sure of the answer on that. Certainly would encourage the court, obviously, to just look at the PSI in its entirety and determine whether there would be anything else, and if so, then obviously then that would make him an A regardless. And I don't plan to address at length from the podium here the Smith opinion. I know this court's aware that we filed a motion for rehearing in that case that this court denied. We would maintain that the arguments that we made in that were correct, but I know this court has reviewed that, and so I don't intend to argue that here from the lectern today. But we do maintain that that was wrongly decided. But yes, to your point, Your Honor, the court would have to look at the entire criminal history in this case, and even if they could show a problem with the convictions that they have challenged, to the extent that there are still 3 that can be aggregated, then he would still remain in the A box.
Other questions? Thank you.
Thank you, Your Honor.
Fran, you reserve 3 minutes.
Your Honor, unless there are further questions, I would waive my rebuttal time.
I don't see any. So
Thank you.
thank you. Thank you to both counsel. We will take this matter under advisement. I will explain that what I mean by that is that the court will begin discussing this case today, and we will assign a justice to write a draft opinion that will be circulated. The other justices will then decide whether they join that. They may edit that, or they may write separate opinions. We will then formally file an opinion in this court at some future date. So thank you. I will now call 126-718 in the interests of K.W.D and E.L.D. minor children. Counsel? May come Smith?
Good morning, and may it please the court. I'm Jennifer Martin Smith. I'm with the Alderson Law Firm here in Topeka, and I represent the father in this case. I find it a little bit easier to refer to him as father rather than by initials, and so that's how I will refer to him through the arguments. Just a brief factual summary. This case was filed in Leavenworth County in 2021, and father, my client, had begun serving a 5-year sentence a year and a half before in 2020. And it was for aggravated battery and domestic violence. It appears that after he had been away for some time, the mother began using some pretty hard drugs and left the children with the father's mother. And there were 3 children originally in this case. My client is only the father of 2 of them. But it appears that the allegations were that the grandmother, the paternal grandmother, may have smacked or hit that other child. That was not my client's. But from the time that he went into prison in 2020, he had been having weekly phone calls with all 3 kids, his 2 children, as well as the stepson. And once this case was filed, he continued having those weekly phone calls until the foster parents stopped them. By the time this went to trial in November of 2022, and then we had the decision in December of 2022, he had a release date, an earliest release date of December of 2023. And he, in fact, was released at that time. And but, I'll proffer to the court that as of this morning at 8:30, he was still out, and he was still following all the conditions of his post-release supervision. The boys in this case are now 7 and 8. And at this point, we would certainly challenge that there was insufficient evidence to find the father unfit under the 3 provisions that the district court found him unfit, which were KSA 382269, B5, B7, and C3. And I recognize that in the Kansas Revised Code for the Care of Children, one factor can be used to determine a parent unfit. But I think in this case, we have kind of this outlier opinion of In Re TH from 2021, where in a very similar situation, a father went to prison, was going to be in prison for a significant amount of time, but he had maintained a relationship with his child. He continued to try to provide for the child from prison, and there was no evidence presented that it was in the best interest of that child in TH to have his rights terminated. And we don't have a lot of published case law in child need of care cases. And when I went back and I looked at all of the cases that have come out since TH, I think they're all really distinguishable. I mean, we have, parents who were convicted of sex crimes against children. We have parents who are going to be in prison until well after the child turned 18. When we're looking at whether a parent is unfit, all of the court's opinions, all of the briefs that I've written over the years, they all start the same way. And they all start with a parent has a fundamental right to parent their children unless they are found unfit. And we hold these rights to be so fundamental. But at the end of the day, we have a father here who didn't commit any crimes against his children. He was not alleged to have abused them in any fashion. And he was kind of lumped in when the mother of these children fell off the wagon, and he had a foreseeable future release date. He had a relationship with his kids prior to him going into prison. And it's not like they were babies who had no knowledge of their father, which is, again, in a lot of the cases post TH, what we see, no relationship, no contact. When we talk about somebody being unfit by conduct or condition to render them to care properly, obviously at the very time of the filing of the termination motion and at the evidentiary hearing, he was incarcerated and could not parent his child physically at that time, or his children. But he still maintained contact. He does all of those things that we ask people to do when they're incarcerated, because, we tell them, hey, you may be incarcerated, but you have a fundamental right to parent your child. And so you need to follow your case plan tasks. Well, he tried to do that.
Are you asking us to adopt essentially a rule of law that a finding of unfitness under B5 alone is effectively unconstitutional?
I'm not necessarily asking that you adopt that, no.
So you're not denying that there's clear and convincing evidence that the statutory factor in B5 was met?
Correct.
And so what is left other than a claim that it's unconstitutional to do so?
Well, there is a factual argument under B5, and that was made in the TH case, that factor may not alone be enough, that there has to be other evidence showing that.
What, under the statute, what rule of law requires more than just one factor? Like, where do we find that rule?
Well, we don't.
So it's not in the statute, right?
No, it's not.
So it would have to be in the Constitution, or are you asking us to look somewhere else?
No, I mean, it would be a constitutional right. We're saying that parents have a fundamental right to parent their children. And when we look at B5, it just says felony in prison.
So just to circle back to my first question, you are saying that a finding of unfitness under B5 alone is unconstitutional?
Yeah, I think I am. I didn't frame it that way.
And is that a problem for the argument that you?
Please. But I am asking the court to, under the TH ruling, they said that didn't necessarily mean unfitness. When looking, he tried to do his mental health evaluation. He was told he didn't qualify. He maintained contact until the foster parents shut it off. And I think that is one of the real problems that we see in these child need of care cases, is we let outside people who don't have fundamental rights to their children to decide that, oh, they're just too busy and he can't have contact anymore. We then have to look at, oh, yes.
Number one, you keep saying that the foster parents cut off the visitation,
Mhm.
but is that really what the record reflects? I mean, the change that happened was that he got a job in prison that made it so during, the period of time where he was available, the children weren't available, correct?
Sort of. He did have a smaller window of availability, but the foster parents said, well, we're too busy in the evenings. We can't let you call until 8 o'clock or later. And so at that point, that didn't even really impact like the job that he had, because he has to have somebody there to make the call, his counselors, and they don't work past 4:30. So the foster parents wouldn't offer any other solutions.
Is there anything in the record to show that he could have gone back to the job that he had before?
No, not that I'm aware
We don't know
of.
one way or the other.
No, whether he could have gone back to a different job, no.
Okay, so when I'm looking at this is a really tough case. I agree it's a tough case. And I think Justice Stiegel raised some really good points because, as the statute is written by the legislature, it says that, it really says conviction and incarceration for, I guess, a felony conviction and incarceration. Boom, 4 words, right? And so when you're looking at that, and I know that you didn't argue the fact that it's unconstitutional, but with that aside, as I really dug through the record, if we don't count anything about agency effort, so just looking at felony conviction and incarceration without any agency effort, so our law pretty much indicates that in exceptional cases, termination of an incarcerated parent's rights is not warranted when the parent actively engages with the reintegration process. The children are doing well despite the parents' incarceration, and there's a viable post-release plan. Here, I would be inclined to, I would be open to the fact that the reintegration plan was really not aimed at him.
No.
There was just a lot of things, it wasn't aimed at him. It was mostly aimed at the mom. They had both had the same reintegration plan. And I would tend to agree that there really wasn't any evidence that the case manager really made reasonable efforts. And I think the Court of Appeals found that to assist Dad. But why did he wait until the TPR to say, hey, these tasks are not applicable to me because I'm in prison. Hey, let me identify tasks that I can and can't complete. And then, basically he waited until the TPR hearing to raise issues and basically treated any kind of interfering circumstances as beyond his control.
Well, I do think the record reflects that he attempted to keep calling the case manager or have his counselor email the case manager to try to figure out how he could get the contact back. And then they were told, oh, well, there's just no way that we can do that. He did reach out for some of the things. I mean, he probably could have done more. I don't dispute that he probably could have done more, but I also think, he's in prison, he's working, he's trying to better himself. And when you're not having a whole lot of contact with the case team, or they're just sending a letter or sending a case plan through an attorney, I mean, he did what he could and he attended those case plans. I don't think he was aware that he could really push back against the agency. I don't think he was aware that he could tell them, this isn't fair. He's told me that since then, but, from his position inside the correctional facility, I think he did what he thought he was supposed to do. And I don't think he was aware, nor was it explained to him, that he could have a say in what those case plan tasks are.
So at bottom, do you think that he engaged in the reintegration process?
I think he did as much as he could. I think he did testify that he was sending money to his mom. He didn't realize that wouldn't go to the children. He was trying to have that contact. When you look at his history of incarceration, the first time he was incarcerated from 2010 to 2013, he had a laundry list of write-ups. And this time when he went in, he promised his kids, like, I'm not going to get write-ups. I'm going to get out. And
that wasn't part of his reintegration process, was it?
Resolving legal issues was part of his reintegration plan. And I think that kind of goes along with that.
And then, the children obviously were not doing well during incarceration. First with mom, and then with the paternal grandma, then with the first foster family, then with the second foster family. So would you agree that there were emotional and behavioral challenges due to instability because Dad was incarcerated?
I think when they talked about the emotional issues with the move and the foster home, I don't think you can attribute that to Dad. They said, that the kids moved from their long-term placement to a new placement because the other foster parent had some medical issues or something. But yes, I think the boys had some emotional issues, but I think those predated his incarceration.
To that end, and this really wasn't brought out, but before incarceration, he said, oh, I didn't know. I never saw mom with the drug problem. Okay. But isn't it true in the record that it shows that because she had a drug problem, he himself took the kids to his parents' house, to his mom's house before he was incarcerated?
I thought that it was after that. My reading of the record was that mom dropped them off with paternal grandmother and just didn't come back. I think they had an ongoing relationship, but my reading of the record was that she didn't relapse until after he went away. And in my conversations with him, that's what he represented to me. And so if I've missed that in the record, I apologize.
Well, I think there was a conflict in the record that he said that and he testified to that, but there was also in the record, but I'll double check that. And then to that end, and I think this is important when it goes to unfitness. Would you agree that dad did not have a suitable post-release plan to properly care for the children? He intended to live with his mom, who was previously deemed unsafe because of credible reports of physical abuse. And then he provided no testimony about how he would care for the children once released, physically, financially, or otherwise, except to suggest, while he testified, mom would be involved because he believed she was a good mom and he would be able to stop her from abusing drugs and attend treatment.
I think that his plan was he was going to get out. And then, yes, he was going to live with his mom for a period of time because he didn't have anywhere else to go. But that would have given the agency time to work on that plan. He could have resumed visits with the children. They didn't have to be at mom's house. It could have been in the community. They could have been at the agency. And then
Why couldn't he work on that plan while he was incarcerated?
I think he should have. I don't think it was something that was brought up to him. I mean, his plan was he was
Well,
going
it's
to
part
get
of the reintegration plan.
right. And so he was
So
going
then
to live.
again, did he actively engage in the reintegration process, or was he just passive?
I think he engaged as much as he knew how. I think he did. He tried to maintain contact.
Is that the standard?
That he engaged as much as he can?
No, as much as he knew how.
No, it's not. But what is the standard? I mean, that's kind of an amorphous question. I mean, what else could he have done?
If the reintegration plan says, what are your plans for taking care of the children when you get out?
Well, and his plans were that he was going to have a place to live. He was going to get a
With his
job.
mother.
Right. And as soon as he had saved up enough money, he
Who
would have
was a
gotten
child
some-
abuser.
I don't think she was substantiated.
Yeah, it was.
But I mean, he wasn't planning to live with her forever. I mean, there was just a period of time where he had to get his feet under him while he worked on that reintegration plan. He could have had those visits. They could have had longer day
And
visits.
then he was going to incorporate mom into the whole thing.
He was saying that when mom is sober, she's a good parent, and he was going to allow her to have contact if it was safe and appropriate. I don't think anybody was asking him to completely cut her off unless she was unless she was using. And I don't think that was really his plan. He wanted mom to be involved because when she is sober, she's a good parent. And we want parents to continue to have safe relationships with their children as long as she was sober.
Thanks for answering so many of my questions.
No, that's all right, Justice Search. Thank you. I'm out of time, but I'm happy to answer other questions if the court has any. Otherwise, I will sit down. Thank you.
Thank you.
Good morning. May it please the court. Sarah Ikenna, Assistant County Attorney for the state of Kansas. This case is compelling to me, I think particularly in the numbers. And I think the fact that father had been out of the home for 18 months before the children were removed from the home is compelling. And I think the fact that the children 1 and 2, after he was removed, they turned 2 and 3. Before he was incarcerated, they turned 2 and 3, but they were 1 and 2 at the time when he was removed. It was 29 months after the children were removed to his release. And counsel is talking about the fact that there are things that he could have done, that he could have resumed visits, that they could have lived, stayed in placement before father was able to reintegrate. Your Honors, when we look at children's time and the amount of time that these children are lacking permanency, these numbers are compelling.
Can I ask a few questions about the numbers as it relates to the statutory factors themselves? So preliminarily, I think we would agree that under subsection A of 2269, the first 2 steps are a finding of one of the factors of unfitness, one of the statutory findings, and a finding that that condition is, quote, unlikely to change in the foreseeable future, right?
Agreed.
But what I want to ask about B5 in connection with that, and B5 is this conviction of a felony and imprisonment. So clearly, this father was convicted of a felony and imprisoned.
Correct.
So that fact is established by clear and convincing evidence. How are we supposed to look at what makes clear and convincing evidence that that fact is, quote, unlikely to change in the foreseeable future when we have a release date?
I think that part of, and it's part of the likelihood that it'll change in the future, that things will change. I think that it is, to use it for totality of the circumstances to some extent. I think the fact that he had had prior convictions.
Well, why does that matter? I mean, this is a very concrete, very specific fact. Have you been convicted of a felony? Are you in prison? There's not going to be much that an evidentiary hearing is going to do about that. You either are or you aren't, right? And then in the foreseeable future, you either are or you aren't. And if you're going to be released within a period of, let's just say 2 years, to pick a number out of a hat, why doesn't that factor fail as a matter of law?
I think that for children to be out of the home, and I think that it's one thing if you have a set of parents and you have one parent that can parent the child, or that you might have an alternative, but when you have children that don't have an alternative other than foster
Why
care.
do any of those other facts matter if we're looking strictly at the statutory factors?
Because I think it matters in that these children in particular have been in and out of in and out of several foster homes, and so they don't have this permanency, and so they're waiting. It's not as if they have a safe place to be where all their cares and concerns are.
Do you think that the factor of unlikely to change in the foreseeable future is contingent upon other facts? Like for some families, it might be 2 years, and for other families, it might be 4 years. Like, that doesn't seem to comport with my notions of fundamental fairness.
No, I don't disagree, and I don't think it does, because I think that.
So where is the line? Like, if somebody's in prison, it would seem to me that the foreseeable future, admittedly, our case law says from the perspective of the children, what's the line? I mean, how do we know?
I think that that's the difficulty. That's the question, I think, is how do you decide what that period of time is? And I think in the case in TH, right, he had a much longer sentence and he had a lot of things set up. He had a bank account. He had a family that was willing to take care of the child.
And that's what confuses me. I mean, the case law and the way these cases get argued, all argue about all these attendant circumstances. But to me, none of that. I guess I'm asking for help understanding why any of those things should matter. When we have a very clear, either you're in prison or you're not in prison. And will that change in the foreseeable future? Like, it doesn't matter what else happens. You're either in prison or not, right?
And I agree with that, frankly. I think that.
What do we do then about subsection F? Because it says the existence of any one of the above factors standing alone may, but does not necessarily establish grounds for termination of parental rights. So I think even 5 isn't an absolute. So there must be some measure of discretion there.
And maybe that's when in best interest of the child and that lesser standard of review comes in, because then we can take in the more subjective factors and talk about what's in the best interest of that child and whether or not this incarceration is going to impact them beyond what the agencies can support.
But I thought the district court didn't just say that your release date from prison would change the reintegration because there were the other problems. His plan was to move back in with the mom and other things, and it was that led to the conclusion that for the foreseeable future, it wasn't just based upon a 10 or 12, what was it, 12 to 13 months release date. That was only a part of the calculus here, because because once he got out, there were problems. And so it seems to me all of that goes into the foreseeable future determination by the district court. Am I missing that?
No, I would agree. I think that definitely, I think had he had potentially, and I think in TH, he had a home that he could return to. So I think that's maybe a difference in that this individual did not have a stable plan, and certainly a plan that fit what the agency had asked of him as far as having an appropriate place to return to.
And so we may end up in the same place. But again, I'm trying to nail down in my own mind the legal steps that are gone through to get to the final decision. I have understood it to be essentially 3 steps. One, a finding of unfitness under a statutory factor. 2, a finding that that condition is unlikely to change. And then 3, a best interest determination. And we tend to talk about unfitness under the first 2 steps and termination under the 3rd step. Would you agree with what I just summarized?
I would agree.
So does F that the chief was alluding to, when F talks about termination, is that wiggle room? I'll call it wiggle room or discretion. I've always understood, at least, correct me if I'm wrong, that discretionary portion of the decision comes under the best interests test.
I would agree.
But the unfitness really doesn't have discretion. It's based on evidence. Do you
Yes.
agree with that?
I would agree with that.
Okay. And you have to have unfitness before you even get to best interests, right?
Yes.
Okay.
So that means you would say everybody that has a conviction of a felony is an unfit parent.
I think it's possible. I think that, and I think the issue, and I think the problem is that you have a child who, absent another parent, that parent is incarcerated and cannot care for that child. He's not going to be there for bedtime, for
But
meals.
not all felons are incarcerated.
True.
Um,
And so I think it's the incarceration piece potentially that
but
really,
or the imprisonment,
yes, because I think there are plenty of people that have been convicted of felons. that are-
even if that's for 6 months.
Yes. Unfortunately, yes. Although I do think that the system that we have with child in need of care cases generally span a longer period of time than that. And so I think that part of the issue is that a lot of these cases come in and we do have steps that we go through and their time limits and their requirements. And so I don't know that a 6-month sentence would necessarily be an issue for a parent because I don't know that we have many cases that conclude within 6 months.
Wouldn't that be because it's not it's the condition is likely to change
I would
within the
agree.
foreseeable future?
And they would have the opportunity, I think, to move the needle and to change their circumstances in the pendency of the case. I certainly think that that incarceration is an issue, and I think that it is an important issue. And I think that this case in particular is compelling because these children have had a very difficult time in care. I think that they have moved through numerous foster homes, if you look at the record, and it has greatly impacted them and their ability to thrive. And so I think that while father may now have things in a better position than they were in the beginning of the case, I think that to potentially ask the children to further wait on him, again, is outside of what's in the best interest of the children. It's outside of child's time. I think that there are serious concerns about behavior issues that's in the record, that these kids have serious concerns and issues that they're dealing with. And I think for a parent who's on parole, who is changing his life, trying to get his life established, housing, income, job, all of those different factors, and deal with the issues that might have brought him to his incarceration, to also be dealing with children who have serious issues from being in the situation that parents' behavior placed them in. The children are now 7 and 8, and your honors, I think that it was brought up early about the phone calls while father was incarcerated, and I don't know that it's fair to say that the foster parents cut off these phone calls. Certainly the phone calls ended, and I think that, again, it was something that was what was best for the children. And I think that there are numerous avenues for father to have communicated with the children, and I don't know that in the record that I saw that there were evidence of letters. I could understand.
How do you mean it was best for the children?
I think that to keep their schedules, they were involved in activities with the schools and therapies and different things. And I think that those were certainly important things for them to address. And I think also the fact that the children at this point are 7 and 8 years old, and at the time that he was removed from the home were 1 and 2, I think is compelling. I don't know that they would have had the same opportunity to form the relationship that the parent had in TH with his child, because I don't know that there was as much time pre-incarceration for them to be able to form that bond. Not saying that there wasn't a bond between father and his children and that that's not an important bond, Your Honor, but we do have children that need permanency and have been lacking permanency for quite some time. 2021, when they were removed from the home, but even further when their father was incarcerated and no longer in the home.
Maybe this question's been asked already, and maybe I'll try it in a different way. Is there any indication in the text of 2269 what the legislature had in mind in terms of a definition of foreseeable future? In particular with the, what is it, the subsection B5, conviction and felony imprisonment?
I don't think it is defined. I certainly don't think it's defined to a point that it would.
Yeah, it's not defined, but I just didn't know if there were any other clues in the text, if we were to look at that sort of all together in harmony.
Just the thing, what I would look to is just the best interest of the child. And I think that standard is what is used, the light that's used to interpret the rest of the child in need of care code in that section. I'm almost out of time. I still have a couple minutes. Judge, if there are any further questions, I would submit to our briefs and thank you for the time.
Ms. Smith? You reserve 2 minutes.
I did, thank you. In just the last couple of minutes that I have, I wanted to talk a little bit about the best interest finding. There was not a lot of evidence on the best interest of these children other than the child time, which is the only guidance that the legislature really gave us on the foreseeability issue. We didn't have a therapist testify about the relationship. The case manager even testified she'd never observed or been present for any of the phone calls. She couldn't really testify about what relationship these kids had with their father. And so I think that, you know, if we get past that unfitness issue and we look at the foreseeability, we have a date when the foreseeability was going to change. And then what was in the best interest wasn't something that was really fleshed out by the district court. But the one thing I really want to end with is I don't know what the court knows about what happens to these cases after. So I've had several appeals over the years where a parent has gone to the Court of Appeals, they've won on a technicality maybe, and they get back to the district court on remand, and the agency says, oh my gosh, your appeal took so long that it's just not in the best interest to have any contact with your kids. And I think the courts need to know that that's what happens. So if the court today were to decide, you know what, you're right, that foreseeability changed in the foreseeable future, and we didn't have a good discussion of best interest, there needs to be instructions going back to the district court that this father have the ability to actually try to reintegrate with his children, because that doesn't happen in the real life, in the real world.
Say that again. That doesn't happen if there's some sort of reversal and so the time period that is attributed to the appeal works against the parents.
100%. That is exactly what I'm saying. I've had specifically 2 cases in about the last 5 years. One of them, they were like, well, we already told.
We've had, it's analogous to a certain extent. We've had adoption cases where that's the fact, and 3 or 4 years later, we have instructed that shouldn't factor into what occurs here in terms of best interest. But you're saying that is not the case in these types of cases?
Not instant cases. Okay. Not instant cases. So
I just wanted to, I guess, one final question that comes along on the heels of what you just commented about, which is essentially a concern that I have and might be shared by some of my colleagues, that when we deal with a fundamental right like this, we have a statute that has so many discretionary cracks in it, I'll call it. So many places where you just get amorphous arguments about and I'm not sure there's anything a court can do about that. I wanted to get your, I mean, does this require a legislative fix if there's a real problem? Or is there anything a court can do about it?
I think the court can remand with specific instructions that we can then use to hold the agency to the fire. I think that's one thing.
Wouldn't we just be adding provisions to the statute if that was the case?
I don't think it's necessary. I mean, I think some of those provisions are there. Like if you say this parent is unfit and they should have had the opportunity to reintegrate, then we should go back and have a reintegration plan. And I guess what I'm telling the court is in practice, that's not what happens. And maybe that can be legislatively addressed by saying the district court on remand shall allow a reintegration plan.
Thank you.
Anything further? Thank you to both counsel for your arguments. The court will take this matter under advisement. We are now in recess until 10:30 a.m.